S23A0702 through 707, Estate versus Cook et al. Charles Jones for appellant, Amanda Clark Palmer, and Devin Rafus for appellees.
Good morning, Council. Mr. Jones, we're ready when you are.
Mr. Chief Justice, and may it please the court, the issue in this case is whether the defendant jailers are considered peace officers within the state of Georgia when they have no arrest powers and where their duties and responsibilities to maintain order are limited to a defined non-public setting. And the answer to these questions is no. We're here today to focus on two competing definitions within the official code of Georgia. There's a definition in Title 16, the general criminal law title, which says that a peace officer is someone with the power to arrest or to maintain public order. The Title 35 definition says that a peace officer is someone who has the responsibility to arrest and to maintain public order. Unfortunately, what we're dealing with here is in Title 17, where the legislature has chosen to leave that undefined, and so that.
But we do have a note in Title 35, Counsel, right, that expressly says for purposes of this title only.
Yes.
Which is a pretty good clue that we ought not be using that definition in Title 17, right?
It would indicate that, however, we also have in Title 16, it says at the beginning that that definition is also, it doesn't say only, but it says for the purposes of this title.
Right. I mean, in other words, as between the two, it says, 16 says we're defining it for the title, 35 says for this title only.
Right. However, some of the text within Title 17 itself makes specific reference to the definition in Title 35.
And how doesn't that hurt you more than help you? That is to say, in other parts of Title 17, they expressly say we're going to use Title 35, but they didn't, as you pointed out, they didn't help us at all here, right? They didn't do so here. It seems like to me that works against you as opposed to for you.
I could see that argument. Our simple position is that it's to read Title 17 consistently. This is the best definition to use to make everything sort of fit together within that title. It seems that Title 17 is presuming that a peace officer, as used in that, you have a question?
If you use the Title 35 definition, you win pretty easily because everybody agrees they don't have the arrest power, right?
There was some discussion about that in the brief, but our contention is that they do not have arrest power.
Let's assume they don't have an arrest power. So your argument would be pretty short on that front. Use the Title 36 definition, and if you could, talk to me about the Title 16 definition, excuse me, and talk about this maintenance of the public order. What is it that constitutes a duty to maintain the public order?
Right. All right, and really that's the central issue that the trial court focused on. And our position is that it is not in this case because the jailers in this case do have an obligation to maintain order. For instance, there is some evidence in the record that they break up fights, for instance, in the jail. It's not a matter of maintaining public order. And the support for that is, it's actually a persuasive authority in this court, a opinion from the Attorney General, I believe it was in 1983, dealing with military police. And what the Attorney General was faced with is, are military police officers considered peace officers within the state of Georgia? And the Attorney General, I believe it was General Bowers, said no, they're not, because while they maintain order, they don't maintain general public order. They maintain order specifically within the military installation, and therefore it's not a matter of general public order. And that's similar to what we have here. The jailers, it's specifically referenced in our transcript at page 200, for instance. The jailers don't enforce the laws of the state of Georgia. They don't go out If they see me driving down the road at 100 miles an hour, thank God they can't pull me over and give me a ticket. They maintain order within the jail. And even in that, they're very limited. They would, for instance, if...
But there is some contrary argument that if they did not perform their function, there would be less public order, right? In their absence, the order would be disrupted.
That is the argument made on the other side. Our response to that is it really depends how far back the chain of causation you want to go. As far as separating the people inside the jail from people outside the jail, that's the responsibility of the deputies. Our position is that jailers, because there's a difference between, as was discussed before the trial court, there's a difference between a jailer and a...
Detention officer?
I'm sorry?
Detention officer?
Well, they're kind of used interchangeably in this case. Corrections officer is a type of officer who has limited arrest powers in certain cases. And because they have those limited arrest powers, they're clearly falling under the 16 definition. But as far as jailers do, their bailiwick, if you will, is solely within the four walls of that jail. And even keeping order within that jail, it doesn't make you a peace officer. And what I'd like to refer the court to is Title 17, 420C, which I can actually put up here on the screen so we can all take a look at it here. It says nothing in this code section restricts the use of deadly force by employees or by peace officers when apprehending or preventing an escape. So what that indicates is that, just because someone is preventing an escape, for instance, or apprehending an escapee, doesn't necessarily make them a peace officer. They could be just an employee of the jail.
So
And
why, I get why the focus for what peace officer means has focused on these two statutory definitions. But given that both definitions, sort of on their own terms, are restricted to either Title 16 or to the chapter in Title 35, why isn't the right place to go to look for the definition just to the common and ordinary meaning of the term? Even if it's a technical term, the use of the undefined term, typically we don't understand as referencing an unreferenced definition elsewhere in the code, right?
Correct.
Is there some sort of ordinary meaning of the term peace officer?
I'm not sure that there is specifically any authority on that. I think that the ordinary person on the street, and we mentioned this in our brief in terms of public place, the ordinary speaker of the English language, how would they understand a police officer? And that's really what they're
Peace officer.
Peace
yes.
officer. And they would generally understand it as someone who is going to arrest you if you do something wrong.
Badge and a gun.
Pardon?
Badge and a gun.
Badge and a gun, yes. And as the record indicates here that these jailers and jailers in general are very differently trained than peace officers. Whereas peace officers have hundreds of hours of training. Jailers go to training for 80 hours. They have no firearm.
I think that's interesting, and that makes sense, but I do think it cuts against your argument about the ordinary meaning, because the person on the street will not know the difference in the training. And I think an ordinary person might say, do you keep the peace? All right, you're a peace officer, right? I mean, so those arguments are helpful in some regards and not entirely persuasive in others.
Right, I understand, Justice Warren, and I think that the way that an ordinary person on the street would understand it is, do you keep the public peace as opposed to in any specific setting? I mean, that's what we're kind of looking for here, and that's what the trial court alluded to, is needing some sort of a limiting principle here, because otherwise anyone who's responsible for maintaining any kind of order is automatically a peace officer.
Yeah,
And
all mothers would be peace officers because they maintain order between siblings.
Yes, I think so. Certainly in my case, Yeah, I would have feared that growing up. But yes, anyone who maintains any kind of order, and we use the example in our brief, judges, trial judges, and teachers, for instance, they maintain order in their classroom. Many of your honors were former trial judges, and you maintained order in your courtrooms. But that doesn't make you peace officers. And now, in an emergency, you may need to call on a peace officer. You may need to call on a courtroom deputy. But that's the same as what's going on here. The jailers, if they break up a fight, they have the authority to break it up, but they don't levy any charges against the people. They would have to call in a deputy to do
Does
that.
the charge point really go more towards the separate definition of arrest power, or is there an overlap between the two? Because on one hand, I feel like I hear you saying, there's a definition about arrest, but then oftentimes when you're talking about the other definition, you're bringing in the lack of authority to arrest.
Right.
Is that a conflation of the two, or is there just an overlap?
There does seem to be an overlap. It's kind of hard to imagine a situation where someone would have the authority to maintain public order without having an arrest power.
What happens all
or-
the time?
I'm sorry?
Happens all the time with private security in public places.
Right, private security, and that's one of the things that was discussed in the trial court, why we're here today, looking for that limiting principle, because we don't want every security guard to have to receive this notice to appear before the grand jury. So with,
Who's responsible for establishing that limiting principle?
well, ideally, it would be the legislature. The legislature has not done so in this case, has not yet done so in this case, maybe soon, but in the absence of their direction, it falls on this court to make the most reasonable interpretation. And that involves understanding no arrest power, no maintaining of public order, though private order, is simply not a peace officer. And otherwise, it just opens the floodgates. And unless the court has any further questions for me at this time, may I hold the balance of my time for rebuttal?
You may, counsel.
Thank
you. Mr. Raffis?
Chief Justice Boggs, Presiding Justice Peterson, may it please the court, good morning. My name is Devin Rafis, and it's an honor to be here on behalf of Omar Jackson, one of the appellees. I and my colleagues, and Amanda Clark Palmer will be arguing on behalf of all appellees today. This case is simply about what is and who is a peace officer for purposes of receiving the benefit and privilege of the notice and opportunity provision of 17752. There are two issues in this case. The first I will be addressing is what definition should we use, Title 16 or Title 35? The second issue my colleague, Ms. Clark Palmer, will address is the fact that the trial court correctly found that our clients, Fulton County jailers, did fall under the definition of what a peace officer is and therefore should have received the privileges of 17752. So jumping right into the first argument. Title 17 does not define what a peace officer is. However, it's listed in 17752. Because it's not listed and defined in Title 17, we must look to other definitions, that being Title 16 or Title 35.
I mean, the question is not, you don't immediately go to other definitions, right? The question is, what is the ordinary meaning of this undefined term here? Those other definitions are potentially evidence and maybe good evidence of what the legislature meant because they're used in a similar context, whatever. But you have to sort of make that leap from, hey, these aren't in this is an undefined term, why are these persuasive as definitions? You don't disagree with that sort of framing, right?
I do not disagree. In fact, I agree with my friend. I don't believe there is a common understood meaning of what a peace officer is to anyone outside, layperson, if you will. So when you look to outside of Title 17, Title 16, or Title 35, the fact that there's not a definition in Title 17, whenever there's any sort of ambiguity in a statute, the court should construe it in favor of the defendant.
Well, we don't start with ambiguity, though. I mean, we start with, what does this mean? If we get to, hey, there could be more than one reasonable meaning of the term, we've tried everything and it's still ambiguous, then maybe at that point you get to the rules of construction. But it seems like you have to start with, what are the permissible meanings of this term?
And so when I look at the permissible meanings, specifically when I look at Title 16 and Title 35, right? Title 16, to me, is the most clear and obvious first choice. And I say that because statutes related to the same subject matter should be construed and should be harmonized together. I cited, in the interest of TB, that's this court's case in 2022. Ultimately, it was just whether insanity defense could be used in a juvenile case. I think it came down to what is an act. It wasn't defined in that juvenile code, so this court looked to Title 16. And Title 16 and Title 17 are like sister titles. They're related to the same subject matter: crimes and offenses, criminal procedure. So that's the first place you should look. The second point I have is that Title 35 has specific applications, right? It's for law enforcement officer or peace officer training. You look at the word school, like I defined in the brief. It's not like what we think in the ordinary meaning of school. It's a law enforcement training facility. And for purposes of that chapter only, I think is crucial as far as what is a peace officer. The legislator specifically made references to Title 35's definition of a peace officer in multiple statutes. The state brought up 17-420, talking about the use of deadly force. Peace officers who are appointed or employed in conformity with Chapter 8 of Title 35. And references in Title 16, 16-1034 is pointing a laser at law enforcement officers. Peace officer as defined in paragraph 8 of 35.8.2. 16-546, dealing with trafficking a person for labor or sexual servitude. They said peace officers shall have the same meaning as provided for in Title 35.
So, counsel, let me ask you a question. To be clear, you want us to employ the Title 16 definition, or, as the presiding justice suggested, is there some other definition? In other words, just sort of common understanding. In other words, I know you don't want Title 35. Do you want 16, or is there some other understanding of what a peace officer is that we should employ?
I don't think there's a common understood meaning outside of the definitions in OCGA.
So here's how Black's Law Dictionary defines peace officer. A civil officer, such as a sheriff or police officer, appointed to maintain public tranquility and order, semicolon, especially a person designated by public authority to keep the peace and arrest persons guilty or suspected of crime. And so at least the Black's definition replaces the disjunctive or in the Title 16 definition with the conjunctive and. What's wrong with that?
What's wrong with that is when I'm looking at, again, I'm going to go back to the fact that similar statutes should be construed together and harmonized together. When you're looking at Title 17, criminal procedure, and if there's any sort of ambiguity or if there needs to be a defined term that's not, you look to the sister title that has the same subject matter, that being Title 16, in which it's maintain public order or arrest powers, make arrests. And the reason I pointed out all the other references, specifically the legislator made a point to reference Title 35, is because the expression of one thing is the exclusion of the other. The fact that they specifically referenced Title 35 definition, if they intended for Title 35 to be the definition in Title 17, all of those specific references would be mere surplusage.
How do your clients maintain order, public order?
I'm sorry, just that.
How do your clients maintain public order?
Our clients maintain public order for a variety of reasons that we laid out in the trial court. One is that you have to maintain the order, right, inside of the jail. Break up fights,
That's
prevent
inside
escape.
jail, right?
Inside the jail. But the fact that they're maintaining that order inside the jail, we could determine if it's public or not, but also protects society outside, maintains the public order outside. And with this questioning, I think it'd be a good transition that I'll pass over the remaining time to my colleague, Amanda Clark-Palmer, unless there's any other questions about the definition aspect of it.
I don't see any, counsel. Thank
All
you.
right, thank you.
Ms. Palmer, good morning.
Good morning, Your Honors. And good morning to my colleague, who I did not get to say good morning this morning. I want to jump in and answer your question right away by citing to the oath that these officers took when they became employees at the Fulton County Sheriff's Office. This is attached to the indictment as an exhibit. And I'm zooming in on the third paragraph, which I think is the most important part. because it requires them not only to faithfully discharge all their duties and to execute the orders of their superior offices, but in all cases conform to and enforce the criminal laws of the state of Georgia, the ordinances of Fulton County, and obey the rules governing the sheriff's office, and report all violations of same that may come to my knowledge.
So that's interesting about this is that I understand why you would say this supports your case. That would fall into the second category that the presiding justice raised, which is that this doesn't fall into either one of the title's definitions, but rather just sort of a common understanding of what a peace officer is and does that's not defined in the statute. You know, especially because even certain aspects of this are internally contradictory. It's saying you have to report, and then you're also enforcing. I guess that's not contradictory, but it does suggest that they don't have the power to do things themselves, which would continue to rule out one of those definitions on arrest powers. So do you think this does fall into a different definition of peace officer that is commonly understood, you know, for people who are in this space?
I would argue that this oath supports the argument that these jailers were peace officers under Title 16 or under the definition from Black's Law Dictionary or under what a
Black's Law
common...
Dictionary is a tough one because that one says you have to arrest.
Well, it says especially those who, which I think...
But it says and arrest.
In that last clause.
Yes.
You know, the first part...
So tell us how this supports the public aspect.
Okay.
Right.
So, well, I think the most important part of enforcing the, or maintaining the public order, that aspect, is that they are required to enforce the laws of Georgia. It doesn't say you're required to enforce, you know, the policies at the jail or maintain order of the jail. It's much broader than that. It goes to the entire state. It also talks about the ordinances of Fulton County, which, you know, govern a variety of different things, some of which are also important to maintaining the public order of our community.
Counsel, outside of the obligations of a detention officer to enforce not only the sheriff's rules relative to the detention, but also state law relative to what happens in detention, what authority do these defendants have to enforce the criminal laws outside of the facility? I mean, are you suggesting that by this oath they somehow have assumed that responsibility as well?
Well, I think that our argument is not that these officers could go out on the street and, you know, start making arrests left and right. That's not our argument. Nor do I think we have to meet that kind of test in order to get the benefits of 17-752.
I mean, this oath doesn't say in public. I
Right.
concede. It says enforce the criminal laws of the state of Georgia. I guess your argument would be that there are criminal statutes or provisions in Title 16 that are equally enforceable behind the wire as they are outside, correct?
Correct.
Contraband and other such things.
Escape.
Possession of drugs.
Right. I mean, let's think of it this way. If somebody were to come to the jail at the security, right, who's not an inmate, right, they're coming to visit or whatever, and they've got contraband, and it's a jailer there at the security, I don't think anybody would think that jailer's going to go, oh, could you stay right here while I go get somebody who could arrest you?
So I think that's right, but why is that the maintenance of public
Sure.
order as opposed to sort of sequestered jail order?
Maintaining the order at the jail maintains the public order of our community. It protects the members of our community from people who have been determined to be at the jail for a reason, as we argued in our brief.
But doesn't that necessarily extend further than jailers? I mean, if the maintenance of order at the jail is sort of necessary to public order, but not itself maintaining public order, what about DAs and public defenders and judges for that matter?
School teachers.
So there, I would also point to, at least in Title 16, we have part of the definition that talks about people who are vested with the authority by law, or I forget the exact phrasing, I've got it written down, or have a duty to maintain public order. And that's where this oath is important, because teachers don't take the same oath that these jailers take. Even judges don't take the same oath that these jailers take. It's a different oath, I think, that talks about, I looked up the wording this morning and now I've forgotten it. I think maybe like administering the laws fairly or something like that.
Without respect to persons, yes.
Yes.
Is the oath, though, the source of the duty? I mean, it's, the language is vested by law. And usually it's the law that establishes the responsibility or the duty. I appreciate the language you're pointing to in the oath, but what law of Georgia says that a jail officer, detention officer, however you want to define that, has the duty to maintain the public order? Not an oath that they took. In other words, I can't swear this oath. I could swear it publicly in front of all these people. That wouldn't make me a peace officer, right?
Well, you just stand up and you just take the oath, other than being
Correct.
in
The
right, that's,
taking of the oath can't be the source of the legal authority to be a peace officer, right?
Or why would they be classified as jailers?
right. So my argument is not that just because they stood up and spoke these words,
Right.
that they're now peace officers, correct?
So what is the legal authority that says people who are fulfilling the role of a jailer, of a, detention officer, have the duty to maintain public order?
Okay, so if I could cite to you a statute that says who has that duty, I would have done it. I'm not aware of one.
Understand.
Okay, so I lost my train of thought. I'm sorry. I wanted to say something
We're talking
about
the
the
source,
oh.
the source of the authority.
Yes. What I wanted to mention is the fact that these officers are also charged with a criminal charge of violating the same oath. So if they have a duty, a legal duty to uphold this oath, or they could be criminally charged for violating it, isn't that a legal support that
But
they have?
every public official is subject to that criminal prosecution. We all take oaths, and we're all subject to criminal prosecution for violating our oath.
Yes, but the wording of your oath is different. You could not be charged,
Is the element of the crime of violating the oath of the detention officers premised upon a failure to maintain public order?
the way the indictment words it specifically is that they were, which requires said accused to conform to the criminal laws of the state of Georgia. That's the way the indictment charged it.
Did the trial court
When
say
they're charged
any-
with murder, that makes sense, right? I mean, that's-
Murder and other charges.
charges.
Yes, correct.
Did the trial court say anything or make any findings or conclusions of law on this point about the oath?
No, the trial court did not specifically reference the oath in either of its orders.
Was it raised below and the trial court just did not rule on it?
We did bring it up.
Because you said it was attached to your. to the
I
complaint.
don't have the, I could give you the transcript site, but it is in there. I believe it was the second hearing we had where we referenced the oath that was attached to the indictment.
Is that the motion for reconsideration?
Yes. I did also want to, if I could just jump back to, going back to, should we look at Title 16 or Title 35? I did want to talk about the Ellis ruling from this court, because in my view, the Ellis opinion implicitly recognizes that Title 16 ought to be the definition of peace officer. So in Ellis, there it was, I believe he was the county CEO, was talking about the section of the code that gives him the right to appear before the grand jury. And there was I think, some sort of constitutional argument.
Counsel, I'm sorry to
Yeah.
interrupt. But before we
Okay.
chase the 16 distinction, is it your argument before us that any of the 6 defendants here had the arrest power?
Well, I don't want to concede that we,
I understand,
Right.
but assuming they did not, then 35 is useless to you, right? Because it has to be the arrest power and.
right, I recognize that.
And so you live in a world where, I don't want to cut you off on Ellis. We have cited the 16
Yes.
definition in Title 17 favorably before, but I think, to me, the best use of the time is trying to
Okay,
really focus on the maintenance of the public order piece.
okay.
Because the arrest thing, unless we have some sort of different articulation of the arrest power, and I'm certainly welcome you're arguing it here, it doesn't seem to help you at all in 35.
Right.
And so you probably want to, I would think, stay with the
Okay.
maintaining public order.
And you've recognized my point, so
Yes,
I'll
yes.
move on. I do want to make 2 other points about extending the protections provided by 17-752 to these officers. The first one is, it would be consistent with what this court had stated in the Ellis case about what is the purpose of this statute. You know, and the purpose is to protect officers who are called upon to make split-second decisions that are often life and death.
Tell
we
me,
do that?
I asked, sorry, go ahead.
Go ahead, Justice
Can we
Coleman.
do that in excess of what the statute says? Are you asking us to do something that the legislature should do?
No, I'm not. I'm just saying that finding that these jailers have a duty to maintain the public order also conforms with what the spirit of 17752 was designed to do. So we should win on the definition of the law and the spirit of the law, and it's also consistent with at least two prior decisions. I believe they were both Court of Appeals decisions that we cited in our brief, which is the Relane decision and then also the State versus O'Neill. Because in both of those cases, we're dealing with, I think both of them were correctional officers, so working in a prison setting as opposed to a jail. But the court there upheld that, yes, 17752 ought to apply to corrections officers, and I believe one was a deputy warden, that they were peace officers as defined by the statute. So our argument is that this court should affirm the trial court's ruling because it's consistent with case precedent, consistent with the spirit of the procedural protections of the statute, and then also consistent with the words in the statute, maintaining public order. And what the trial court found and what we argued is that protecting or maintaining order at the jail does protect the community at large. That's the public order that is being maintained. As we argued in our brief, you know, people who are in jail, there's been a judicial determination that they ought to be there. Either they've been denied bond for some reason, or they're serving some kind of sentence, and they should not be out in our community.
So it's clearly a necessary precondition to public order. I'm not sure that it is itself the maintenance of public order. And there are a lot of other things that are necessary preconditions to public order that we wouldn't think as capturing peace officers, right?
There could be.
I mean, a properly functioning judicial system is a necessary precondition to maintaining public order.
Right.
Why is the order that they keep public order? Is it simply the effect that has on the broader public, or is something about what they're doing in the jail public?
Well, our argument is that the effect of what they're doing is maintaining the public order at large, but the trial court also noted in its order that there are people who are not inmates who are at the jail, and those people are also being protected by the functions that the jailers serve there. So since my time's up, I'll
Thank you, Ms.
sit down.
Palmer.
Thank you.
Appreciate the fine argument. You have some time left.
Thank you again, Mr. Chief Justice. I just wanted to hone in a little bit on the business about public order in response to Justice Colvin and Presiding Justice Peterson's questions. And I respectfully disagree with my learned friends that order in the jail is necessary public order. To be quite blunt about it, I mean, maybe this is just me, but as someone who's living outside the jail, I don't care if there's a fight going on inside the jail or not. There's probably one going on right now, but that's not a matter of public order.
I mean, I think the system cares about whether there's a fight going on in the jail. We don't want that to happen.
Yes.
Why is a sheriff's deputy who is keeping order in a particular courtroom maintaining public order in a way that jailers aren't?
A courtroom deputy
Yes.
in a particular courtroom.
Let's say the courtroom has been closed under the existing precedent for closing courtrooms after making certain findings. The public can't go in that courtroom.
Right.
Why is the maintenance of order in that courtroom at that moment maintaining public order if jailers don't maintain public order?
I'm not necessarily sure that it would be public order, though that courtroom deputy does have the arrest powers, and that's why he or she follows.
All of them don't.
Oh.
All courtroom deputies don't
That's
necessarily. So let's assume
something new
it's
to me.
just a retired former deputy, no longer post-certified, is just working in a courtroom with a badge and a uniform but no gun. Public's in the room. Is he maintaining public order and therefore a peace officer?
Yeah, that's an interesting question, and I had always assumed from the record in this case that all of the courtroom deputies were in fact authorized to make arrests. But in that case, it very well may be that if there's an emergency that happens in that courtroom, he's in the same position as the judge would be to say, okay, we need to get somebody in here with arrest powers who does have that gun and who can deal with the situation. With respect to the oath that my learned friend mentioned, it's important to, look, if you read that oath very broadly, it actually uses the qualifier in all cases to enforce the laws of the state of Georgia, which, if you read it as broadly as the appellees would prefer that it be read, if a jailer is just out on the street on a weekend shopping and they see a crime going on.
I don't think they were trying to offer reading that broad. I think what they were trying to offer the oath for was the point that in the course of their duties within the four walls of the jail, that they have authority to enforce the laws of the state, and if they have the authority to enforce the laws of the state, that they are then, their duty is to the public.
Right.
So I did not take the argument as to saying they could just wander about and enforce the laws in various ways.
Right. Yeah, I certainly understand that, but, again, looking at the
But
text.
you would acknowledge that enforcing the laws is essentially, functionally a synonym for maintaining public order, right? If there was a statute that said it is the legally imposed duty under this statute that jailers enforce the laws,
That would be a much trickier case for our side, certainly. And, but of course, again, the issue is where is that limiting principle? Judges.
You would agree that oath presumes an obligation to enforce the laws beyond just the laws as against the people who are detained. It could include visitors, correct?
It could.
The public. They don't lose their status as members of the public by visiting folks in the detention facility, correct?
Right, clearly not. Clearly not. And, but again, if you read that oath that broadly, then they would be doing wrong if they didn't go and arrest somebody out on the weekend. Because, again, that particular text in there, in all cases, enforce the law. And therefore, I don't think it should be read that broadly. I think it should be read in the context of the record in this case. And the testimony in this case, there was some testimony from the director of the Peace Officers Training or Standards and Training Council, specifically indicates that the jailers do not go out and enforce the laws. And so with respect to that oath argument, it should be read in context with the testimony presented in the record. Of course, with respect to the purpose, I can certainly understand the legislative purpose of, when someone makes a split-second, is in that position where they have to make a split-second decision, that you respect those circumstances, and the legislature has occasionally recognized that by giving immunity, but they've done so explicitly. And consider also trial judges. Again, I keep referring to that example. Trial judges, they're in there, there's a jury present.
Your point, counsel, is that nothing prevents the legislature, it's not immunity,
Right.
but the notice could be extended to these to jailers. But also, the district attorney's office could have extended that on its own. It could have simply said, we recognize that there's a dispute over whether you're peace officers. We're going to notify you 20 days in advance. We're going to follow this procedure as a courtesy. It could be extended.
Yes.
The question is whether it was extended.
Right.
And your argument is that it's not, right?
Correct.
So if we look at Title 16, tell me, to make sure that I understand the state's view of the maintaining of public order, what is included? Jailers, your understanding is jailers are not. What is included?
Any place where it's an undefined area, anybody can come in. There's no restrictions. For example, the courtroom deputy who has arrest powers.
Is a school?
A school.
It's a secured
School resource
location.
officer.
I'm sorry?
School resource officer.
School resource officers, yes, they do have,
Even though a school has limited access?
has limited access, but it's not completely, prohibited.
Well,
So-
neither
that's
is
the
jail.
same
The
as
jail has limited access.
Well, that's true.
So what's the threshold of maintaining public order?
Right. think it goes back again to the ordinary speaker of the English language would understand as a public school, okay, if my children are in public school, I can go visit if I have a reason. And I believe that the statutes speak to that. They say upon request from the school staff, you must, explain the reason why you're there. They would not say that a jail is just a place you can ordinarily go into.
So I think you've pretty clearly argued why the statute doesn't apply to these folks, but we're still having trouble figuring out what this universe of applicability is. Are
Right.
there certain categories of folks that you would say, generally speaking, fall into the ambit of this statute?
Well, there are,
Police officers.
yes, there are police officers, there are probation officers, for instance, which.
So a probation officer would be afforded this protection, but a jailer would not?
There's really no discussion about that below, but I'm just thinking out loud here that the probation officer is dealing with someone who is out in the public and is not confined in that
I mean,
area. So-
it sounds like you're arguing that either they need to be charged with maintaining order out in the public or in an enclosed space that is open to the public. Is that your rule?
That would be generally fair to say that public order generally open to the public with few restrictions.
Does a probation officer have the authority to effectuate an arrest against someone other than a probationer?
May I answer them? There's nothing in the record about that, and I personally don't know, Justice Boggs. I have never had that pleasure.
All right, thank you, counsel. Appreciate the fine arguments. We're going to take a recess of at least 10 minutes, and we'll come back for the final case.